Okay, this is a question, a divorce question related to Illinois divorce from one of our loyal followers, and I'm going to do my best here. This is really a two-parter because the person says, what is the process for filing an appeal to a divorce trial judgment? Hi, Rayford Palmer, the divorce lawyer, Chicagoland divorce attorney, managing partner, STG Divorce Law in Chicago. I don't know if you can see the logo there, but I'm answering your divorce questions. This one kind of complicated. The person is basically saying, how do you file an appeal? Well, the short story is get an appellate lawyer. Don't dabble in this yourself. There are too many complicated rules. Secondly, you have 30 days after the entry of a final divorce judgment to file a notice of appeal, and you must make that deadline. And then you've got to do technical requirements about filing the briefs and all that stuff, and you might have to do an oral argument. You really got to know your stuff when you do an appeal. You need to know your stuff if you're going to try a divorce case. You really need to know your stuff if you're going to do an appeal. There are very few divorce attorneys who do appeals because it is very technical work. Then the person explains why they're thinking about appeal. They don't even have a trial decided yet, but they're concerned because they say, as what I'm hearing from my attorney, the judge will make decisions based more on testimony rather than evidence. And I think what they mean is more like verbal testimony than documents. And I can tell you evidence includes verbal testimony and documents, and the judge is going to make a decision as to whether that verbal testimony or oral testimony is credible. And when people testify to things, they are subject to cross-examination, which means the other lawyer gets to ask them questions too, to see if they're, to try to probe them and make sure they're telling the truth and maybe impact their credibility, and maybe the judge doesn't think they're believable. Or they might stick documents under their nose to look at that contradict things they've said. Plus, your testimony will be considered, the things you say against it, and things other witnesses say will be considered against what the other party says, and documents. So, you got to take that into account. So you talk about loans to the family and paramour, attorneys not been provided with legitimate loan documents. Okay, well, that's in your favor. If there aren't any legit loan docs, that should help. Your lawyer says they think the judge will consider those loans valid based on verbal testimony. Well, I don't know that, and you don't know that until you try the case, unless the judge has said something to you at a pretrial or to your lawyer saying, yeah, I think these are legit so far. But there hasn't been any testimony taken yet, so nobody knows whether the testimony is credible or not, or how that witness will look under cross-examination, or what else. So there's too many question marks here. So you said there's no evidence of influx to the accounts, I think meaning you don't see any money transfers. Recently had a new judge. I don't think I'll receive a fair trial. That's a whole lot to unpack, but I can tell you have 30 days to do an appeal. Try the case first before you get bummed out and worried about appeal.